Today, I'm going to talk about the top 3 ways that a quitclaim deed can burn you. One of our most requested services after a buyer has closed on a property that they do not intend to use as their primary residence is to change the way that they own their property by using a quitclaim deed. And although the preparation and recording of this sort of deed can be done relatively quickly, it's not a quitclaim deed, it's a quitclaim deed. A quitclaim deed is a legal document used to transfer all or part of the ownership interest in real estate from one person or entity to another. But unlike other types of deeds, quitclaim deeds do not come with any warranties or protections that the interest being transferred is free of liens, or even that the property is legally owned by the party signing the deed to transfer ownership rights. The first step in deciding whether a quitclaim deed is right for you is to speak with your real estate attorney and your accountant or tax attorney, because this simple action can have a number of unintended consequences. When I speak with a property owner who has a change in mind, such as taking the property out of her individual name and titling it in the name of a Florida entity, like a limited liability company, I ask a number of questions to be sure that the change suits the goal that she's aiming to achieve. And she isn't just making this request because it's something her neighbor did. The goal of that conversation is to be sure that the property owner is making an informed decision. Some of the issues that may apply to a quitclaim deed that changes ownership from an individual to an LLC may be solid reasons not to proceed with that change are: 1, the loss of your owner's title insurance policy. Your title policy's jacket includes definitions section. You'll want to look up the definition of insured under your policy to see if coverage will continue to the LLC after recording the quitclaim deed. 2, the payment of documentary stamp taxes, or doc stamps. If there's money being paid as consideration for this ownership change, doc stamps are due to the county at the time the deed is recorded. Keep in mind that the county considers the existence of a mortgage with a balance due to be consideration and charges doc stamps when the deed is recorded. And 3, the potential increase of your property tax bill. An ownership change is an opportunity for the county to reevaluate the assessed value of the property, and if it has increased since the property was purchased by the current owner, the tax bill will likely increase as well. Your liability concerns may be handled instead by a property insurance policy instead of a change in ownership. There are other potential consequences to be aware of, such as being considered in default under your mortgage, or in the case of transferring property to someone during your lifetime, instead of them inheriting it from you, the exposure for gift taxes now and capital gains taxes down the road. Viable solutions to those issues may be to deed the property to a revocable trust or to use a different type of deed, such as a life estate or ladybird deed. If you'd like to discuss which option may be right for you, send us a text to 561-225-2676.